Hello, this is business law presentation. I'm Angel.
I'm Henry. I'm Oswald.
In this video, we'll focus on the topic of the termination of contract of employment. Please enjoy. First of all, we will talk about the notice of termination and the wages in lieu of notice. When the employee is under the probation period less than a month, there is no need for notice so that no wages should be paid for the notice period. However, if the probation period is longer than 1 month, in case there is an agreement to the length of notice, it will follow the agreement but not less than 7 days. The wages paid should equal to the amount of wages for the notice period. In case there is no agreement made beforehand, the notice period should not be less than 7 days and the wages paid should also be not less than 7 days.
So, how about after the probation period? If the probation period is over, the length of notice period should be consistent with the agreement, but not less than 7 days. The amount paid should be equivalent to the amount of wages for the notice period. If there is no agreement on the length of notice, the notice should be given a month earlier, and equivalently, the wages paid should not be less than 1 month's wages.
There are some situations that the employer can dismiss the employee without notice and payment in lieu of notice. For example, if the employee disobeys a lawful and reasonable order from his employer. Second, if the employee misbehaves himself. Third, if the employee is guilty of fraud and dishonesty. And fourth, or if he is habitually neglectful in the duties. The employer can terminate the contract without prior notice.
On the other hand, an employee can also terminate the employment contract without notice or payment if he reasonably fears physical danger by violence or disease. Second, he is subjected to ill treatment by the employer. Third, he has been employed for not less than 5 years and is certificated as being permanently unfit for the type of work engaged.
However, there are situations where an employer cannot dismiss an employee. For instance, an employer shall not dismiss a female employee who has been confirmed pregnant and has noticed the employer for pregnancy. Also, an employer shall not dismiss an employee who is under paid sick leave. Furthermore, an employer shall not fire the employee who are giving evidence or information to authority in assistance for the enforcement of any labor legislation. An employer should also not dismiss employees for engaging in trade union activities. Moreover, in case the employer is injured during his course of employment and is waiting for a medical report or a certificate of assessment, the employer should not fire the employee before having entered into an agreement for compensation. If any employer violates the above regulations, he is liable to prosecution and, upon conviction, penalty of 100,000 Hong Kong dollars.
Next, we will discuss the issue of termination payments. There are a number of factors that affect the items and amount of payment payable to an employee on termination of employment or expiration of the contract, such as the length of service, the term of employment contract, and the reason for termination of contract. Here are some references for the termination payments: the outstanding wages, wages in lieu of notice, payment instead of any untaken annual leave, and any pro rata annual leave paid for the current leave year, any outstanding sum of end-of-year payment, and pro rata end-of-year payment for the payment period, long service payment, or severance payment and other payment under the employment contract, like gratuity and provident fund, etc.
There are also some guidelines for the time of making terminance payments. The employer should pay all the termination payments except for the severance payment to the employee as soon as practicable, not later than 7 days after the termination of expiration of contract. For the severance payment, an employer shall make the payment no later than 2 months starting from the receipt of the claiming of the severance payment.
If the employer fails to pay the employee within the time limit, he is required to pay the interest on the outstanding wages and the principal amount. If the employer fails to pay the termination payment when they become due, the employer is liable for prosecution and upon conviction, penalty for 200,000 Hong Kong dollar, as well as imprisonment for 1 year.
By now, I'm sure you have a better understanding on the termination of contract of employment. Thank you.